So welcome everyone. Thank you so much for joining. My name is Paco Jimenez Salinas. Please remember that there is translation available. So you will see a button in the form of a globe at the bottom of the screen, and you should click on it and choose the channel, either Spanish or French, that you would like. Por favor, si desean que sea traducida, si desean acceder al canal en donde hay interpretación, hay un botón abajo de la pantalla, pueden hacer clic en él y entonces elegir el idioma que prefieran. So thank you so much for joining. My name, as I said, is Paco Jimenez Salinas, and I am part of the independent redress mechanism of the Green Climate Fund. We are really excited to meet you all again and to have the opportunity of discussing new and important topics of accountability of financial institutions. Let me now briefly go through the agenda of today's webinar. Next slide, please, Safa. Yeah. After introducing the objectives of this webinar, we will go to a short meet and greet exercise, and then we will have 3 presentations. The first one on an introduction of the IFC Performance Standard on involuntary resettlement and land acquisition, that is going to be presented by our colleague Tiffany Hodgson. Another presentation on a compliance advisory ombudsman problem-solving case presented by Ben Schoman, a external mediator to both the IRM roster of mediators and also the Compliance Advisory Ombudsman roster of mediators. And the last presentation will be on an Asian Development Bank accountability mechanisms compliance review case from Cambodia. Mrs. Antwat Hartman and Dr. Lana Silva will be the presenters for this one. At the end of these 3 presentations, we will have a Q&A section. If you have questions for Tiffany, please put them in writing. You can post those questions in writing, but Tiffany might need to jump off to another event, and she then, if she cannot stay with us, she will then reply in writing after the webinar. Now, a couple of words on the objectives of today's webinar. Those who participated in last year's webinar will remember that presentations were addressing key topics on the setting up and administering of grievance redress mechanisms. When planning for this year's webinars, the grant partners decided to shift the focus on the substance of managing cases. So this webinar's goal is to provide practical examples of challenges and opportunities offered by both problem-solving and compliance review processes, as well as to showcase their specific features and outcomes when applied to specific cases. In addition, today's webinar and the next 2 of 2022 will be structured around particular performance standards. In this webinar, we will examine cases where performance standard 5 on involuntary resettlement and land acquisition was at the core of the complaint. As for the presenters today, they are well-known members of our community, either because they are currently managing a grievance redress mechanism, as it is the case for Dr. Lala da Silva and Antwat Hartman, or because they regularly assist accountability mechanisms in resolving complex cases through mediation, as it is the case for Ben Schoman. For the presentation on the IFC Performance Standard 5, we have invited someone working for a parent institution, in this case, the Green Climate Fund. Her name is Tiffany Hodgson, as I said, and she is the Environmental and Social Safeguards, Gender and Indigenous Peoples Manager of the Green Climate Fund. We invited her not only because she's a recognized expert in the field of environmental and social safeguards, but also because with her participation in one of the grant community events, we want to showcase the importance of collaboration between teams of parent institutions and their accountability mechanisms. Now, before we move to the meet and greet exercise, I want to inform you that we are recording this webinar. And as I said before, also please use the chat box to pose your questions and comments, and they will be answered during the Q&A section. If you can, please open your camera. Now, let's, please, Safar, move us to the greet and meet exercise. You will be automatically sent. So yes, you will be automatically sent to a breakout room. Please introduce yourself, tell the people in your group your name, where you work, and something personal like where you're based or what are your plans for the weekend. After this short exercise, then Tiffany will start with her presentation.
Shall I start, Paco? Is everyone here?
Tiffany, you can start. I think everyone's here.
Everyone's back. Okay, welcome back from the breakout room. So thanks, Safa, for displaying my slides for me. Good day, good evening to all the participants. It's really a pleasure for me to join this session. My name is Tiffany Hodgson. As Paco mentioned, I'm the Manager of Environmental and Social Safeguards, Gender and Indigenous Peoples Issues at the GCF Secretariat. And I'll be giving an overview of Performance Standard 5 on land acquisition and involuntary resettlement. If you can go to the next slide, please. Thank you. Yeah. So just to put the presentation in context, at the GCF, we apply the International Finance Corporation's performance standards, as you know, and these are our interim environmental and social safeguard standards. Our ESMS incorporates many things. As you can see here, it incorporates our environmental and social policy, which was revised last year, September, to further emphasize the GCF's zero tolerance of sexual exploitation, abuse, and harassment. We also have the environmental and social safeguard standards of the fund, which, like I said, are the performance standards. And we also have a gender policy and an Indigenous peoples policy. The business model of the GCF, and in alignment with the GCF's risk management framework, gives the responsibility of first level due diligence to the accredited entities, as you all know. So the accredited entities apply the safeguard standards, and we are responsible at the GCF for the second level due diligence. So having a look at the first level due diligence. Next slide, please. So here you can see the 8 environmental and social standards, with number 5 being the topic for today. And I want to talk a bit about the objectives of safeguarding in line with Performance Standard 5. The objectives are many, but to encapsulate them in a nutshell, it's to avoid or minimize displacement by exploring alternative project design. That's really important. Avoiding forced eviction is a very strong objective. AEs should anticipate, avoid, or minimize impacts from land acquisition or restriction on land use. If those impacts really cannot be avoided and there are no alternatives, then there should be compensation of lost assets at replacement cost. And I can't stress enough the importance of adequate disclosure of information, in addition to informed consultation and participation of affected communities. And this can really assist in avoiding grievances later on. A further objective of applying Performance Standard 5 is to restore or preferably improve the livelihoods and standards of living of displaced persons, and also to improve living conditions. I mean, in the end, we really want to improve things. We don't want to just restore things. So improve the living conditions among physically displaced persons through things like adequate housing with security of tenure in the new housing. And that's really important. I'll come back to that in a little bit. Next slide, please. Here we're going to talk a bit about structure. Scope of application. So what does the standard apply to and what does it not apply to? The AEs apply Performance Standard 5 when land is acquired through expropriation or other compulsory kinds of legal procedures. It's applied when land is acquired through negotiation with property owners, where expropriation is also possible, and where there are involuntary restrictions on land use or access to natural resources, where communities have usage rights. It's not applied if it's really truly a willing buyer, willing seller situation. This means that it does not apply to resettlement resulting from a voluntary transaction. It also doesn't apply when a project does not change the land use. So Performance Standard 5 is very much tied to land use. It doesn't apply when impacts on livelihoods or income are not a direct result of land acquisition or land use restrictions imposed by the project. In that case, other performance standards would be triggered. This standard can be applied at any stage of the project, where project impacts on land, assets, or access to assets become significantly adverse at any stage of the project. The AE needs to apply the requirements of this performance standard, even when there is no land use restriction. So such a situation would be something like for communities that would live close to a new airport with consistently high sound levels, then the guidance note for this performance standard outlines instances like this and gives guidance on how to approach them. So where impacts to people might be the same as if there was land acquisition. The people literally cannot live there anymore due to the discomfort levels. In such cases, Performance Standard 1 of the 8 applies as the umbrella standard safeguard, but the principles of Performance Standard 5 would also need to be applied. And I think, as you all know, Performance Standard 1 is kind of an umbrella in general anyway. It's all about the assessment and management of environmental and social risks and impacts. Next slide, please. All right. Some of the main concepts I want to also outline before I start talking about this slide is some definitions. Sorry, I'll come back to that one. I'll go to this one first, and then we'll come back to the definitions. So understanding compensation and benefits in relation to displacement is important. And I've pulled this out. I mean, the performance standard is really broad, but there are some key things that I want to highlight for this particular meeting. So in relation to displacement, there are different compensations and benefits depending on the type of displacement and depending on who is involved. So it's important to say upfront that forced evictions should not be carried out except in accordance with law and in accordance with the requirements of the standard, which includes things like fair compensation, and that's really important. So looking at the table, if we're talking about a landowner that's economically displaced, for instance, they're losing their farmland, you see that the compensation should be preferably land for land compensation or the replacement cost. If that person is displaced physically, their home is on the land, then they should also get the replacement cost paid out or be resettled. And here it's important that they have choice, right? So they have the choice of housing of the same value. They should be able to choose either self-relocation if they prefer that, or to be resettled by the project. Often people are both physically and economically displaced. I'm sure, as you can imagine, somebody with a farm and the house on the farm, that would be the case for them. So these kinds of compensation would need to be looked at in parallel. If we're talking about informal land users, for instance, when informal farming happens on land, or people are gathering non-timber forest products as a livelihood, for instance, from land, then they would not receive compensation for the land, but they would get paid out for any assets on the land and also get a moving allowance. If they are living on that land, even informally, then their assets on that land would be paid out at replacement cost. As you can imagine, many times these kinds of informal settlers don't have a lot of assets to begin with. So this can be a tricky issue, is valuing their assets on that land. But they do need to be valued and they do need to be compensated. And they also need to be compensated with adequate housing, with security of tenure. This is a really important aspect of development-focused financing and of the performance standard. Next slide, please. So the Performance Standard 5 also includes guidance on stakeholder engagement and grievance redress related specifically to land issues. Engagement with affected communities must follow Performance Standard 1. And this means that decision-making processes should include options and alternatives. And there's a lot that Performance Standard 1 covers. Other standards can also be triggered depending on who is being consulted. So for instance, if it's Indigenous peoples, then Performance Standard 7 would apply as well. And then there's issues around free, prior and informed consent. But all of these work together, and for Performance Standard 5, the consultation is also included and included in the guidance notes as well. What it means there is that relevant information must be disclosed. That's very important, transparency. And the AEs or partners must engage with affected communities during the cycle. So during planning, during implementation, monitoring and evaluation throughout. Additional provisions apply to consultation, like I said, with Indigenous peoples. That's a different standard, but they also apply here if Indigenous peoples are affected. Under the GCF, the Indigenous peoples definition is relatively broad. It does also include local communities and hill tribes, Afro-descendants, etc. A grievance mechanism must be established if there are land issues, including a mechanism to resolve disputes. And grievance redress must be tailored to land acquisition issues and concerns with staff capacitated on these matters. Next slide, please. So some of the key issues that can arise, and this is something I want to focus on, is they're highlighted here, and I've touched on a few of them already, but things like a focus on cash compensation only should be avoided. There are many other important aspects of resettlement, not only paying someone out. And by having a narrow focus and not taking into account the full standard, grievances can definitely occur. So I think that's an important one. Valuation methods are also important. If the land is purposefully undervalued, for instance, then the other party is being treated unfairly. And this can lead to complaints and the need for grievance redress. Eligibility criteria and entitlements are important. I talked earlier about tenure. If someone is resettled, they should get the titles to the new property. This is part and parcel of the whole process. It can't just be neglected. Informal settlers should also not be disregarded. They are also covered under the performance standard. Compensation should be paid in a timely manner so that those displaced don't experience undue challenges, undue stress. As I'm sure you can imagine the kinds of situations vulnerable people might be put in. Compensation that's done in a timely way can really ease their stress and their challenges that they're facing. Livelihood restoration is also important. People shouldn't just be physically moved, but their informal sources of income also need to be looked into, as these things may become non-viable due to the resettlement. You can imagine if somebody has a small house, and from that house they also operate a hairdressing salon or an informal kiosk, for instance, and they're moved into a different area or a different house, they may no longer be able to do what they were doing before with the same customers. So all of these things need to be looked at, not just the house itself. Lastly, the initial environmental and social impact assessment, the ESIA, needs to be done well right from the start, right? To take into account all of these issues around land acquisition so that they're identified and mitigated right from the beginning. The impact of projects on the poor and vulnerable must be an important consideration in project design, and feasible alternatives, and I say this again, to the design should also be explored. These can be explored with engineers, with the project designers. Usually there are alternatives to acquisition and resettlement. So I think with that I'll end, and thanks again for your attention. And please, like Paco mentioned, if you do have any questions about this performance standard, you can write them in the chat and I'll be collecting them from there. And I think Paco can also share my email address, and I'm happy to engage afterwards. But thanks again for inviting me, and happy to engage further.
Thank you very much, Tiffany, for this very interesting presentation. Yes, please pose any questions or comments for Tiffany on the chat box. And if she stills with us at the end of, during the Q&A section, she will respond directly. Otherwise, we will make sure that you all get responses on your questions. Now, let's move on to Ben Showman presentation. Safa, can you please, Ben, you are sharing your own slides, right? You are on mute, Ben. You're on mute.
Yeah, let me see if I can share. Otherwise, I will ask you to do it because I have a feeling I'm going to disappear. So
As you wish. We have your presentation, so.
All right, then perhaps you can share.
Okay, Safa, can you please share Ben's presentation? Thank you.
Great. Okay, so perhaps just very quickly to start, yeah, thanks very much for the opportunity. I'm going to just briefly tell the story of a case we did in Uganda. But these things are always, or these matters are always hugely complex. I've tried to, for the purposes of the presentation, just simplify the story, draw out the key aspects of the story. Things are never as straightforward as I'm going to present them. Many of the facts were contested and probably still are, but I hope we can get value out of the story in any event. So this was a case that came up in Uganda in, well, the events took place in 2009, thereabouts. You can go to the next slide. I'm going to just break it into these 5 sections. I'll give a bit of background and context, then look at the complaint that was brought, the challenges we experienced, the solutions that were developed, and some of the outcomes. It was a case that was done by the Compliance Advisor Ombudsman, the CAO, after a complaint was brought by a local community, and I'll go into that background on the next slide. If you could go to the next one. Okay, so some of the background is that the next slide? Could you just go one back, please? Yes, there we are. So Uganda had a situation where national forestry reserves were promulgated many years ago, and they were largely protected for a long time. People weren't allowed to settle in those reserves. They were reserved for growing of trees and commercial forestry. But then over time, a lot of changes happened, and particularly under the Amen regime, people were allowed to encroach, was the term that was used, into these forests and settle in the forests. And some people had lived in these forest reserves for some time before this case arose. They had, or in Uganda, have a very complex tenure system where you have traditional land, you have what looks more like formal title. You have lease forms of lease tenure of various types. So it is a really complex land tenure system. But in any event, people were settled in these national forest reserves, and the one we're looking at, some 250 or so households had settled in this forestry reserve. And then a forestry company, a commercial forestry company, was given a license to operate a commercial forest in this reserve, and the people who had settled in the affected community were evicted from the forest. And one of the complications, additional complications, was that the IFC had invested in an intermediary institution, which had then in turn invested in the forestry company. So it wasn't a direct IFC involvement in the forestry company, but in this intermediary. Be that as it may, you can go to the next slide. There was an eviction, at that stage, and these are some of the contested facts, but let's just assume no compensation or resettlement was offered by the Ugandan government at the time, or at least it wasn't made concrete. The government insisted on describing the affected community members as illegal squatters or encroachers in the forest. Some members did have or claim to have formal title to their land in the form of various documents. The government of Uganda always rejected that. And the community eventually approached Oxfam, who helped them bring a complaint to the IFC and to the CAO. Next slide, please. This is just a brief picture of the timeline to illustrate that this was a fairly long engagement from when the complaint was brought in around in 2011 up to the engagement finishing in 2018, 2019, thereabouts. So it was a long engagement. The dispute resolution, the community chose dispute resolution. The community and the company chose dispute resolution rather than go to a compliance exercise. And that dispute resolution process took more or less 2 years before an agreement was reached. And there was that was followed by a 4 or 5 year implementation program of the parts of the agreement, where the CAO stayed involved and monitored the implementation of the agreement. Next slide, please. Okay, so the complaint that was brought very much along the lines of performance standard, the performance standard 5, was that firstly that people had lost their land and livelihoods. There was a lot of emotional damage that went along with that, but also financial impacts, security of tenure impacts. There was physical harm. It was most certainly not a voluntary eviction, although again there were some claims made that community members moved voluntarily. The community themselves always denied that. They said they were very forcibly removed. They lost their homes, land, livelihood, amenities, etc. The forestry company claimed that they had nothing to do themselves with the eviction, that the eviction was carried out by the government of Uganda in the form of the National Forestry Authority. And the company felt that it had been unjustly, its reputation had been severely damaged in the process. So the dispute resolution started on that basis. What can be done to make right as far as the community is concerned and help the company recover its standing and reputation and its right, its legal right to operate a commercial forestry operation in the country. Next slide. Okay, so some of the challenges, I've touched on a few of them. In Uganda, there is a system where government can expropriate land for purposes of national interest or development or so on. But that has to be, in terms of the Ugandan law and constitution, has to be followed with, with resettlement and compensation. In this case, government claimed that the affected community had no right to this land, so it wasn't. They didn't qualify for resettlement or compensation. That was the claim that was made. The community claimed that the company was directly involved in the eviction itself, but since they'd chosen dispute resolution, there wasn't an investigation, compliance investigation. So the facts didn't need to be established for them to negotiate and come up with a settlement. I think we can go to the next slide. The role of the government in terms of challenges remained a complication. Government very early on in the process took a position that we couldn't discuss compensation or resettlement wasn't used, the word wasn't used, but there was a clear indication from government that compensation would not be acceptable in a case like this. So we had to find another way to come to some kind of agreement that would lead to resettlement and redress of some kind. And a lot of the work was done around how that could happen. The complaint itself came some 2 years after the eviction, and our process only really kicked off some years after that. So that just the time that it passed in the interim made things really complicated. People had been dispersed, affected community members had settled elsewhere, had kind of found their own way to get by. So that was a complication, just bringing the affected community back together. There was incredibly deep distrust between the community members and this company, who they saw as the as the entity that had got them evicted. So that made things really difficult as far as dispute resolution was concerned initially. As I say, we had a fairly antagonistic government entity involved for quite a while. We had to work very carefully around doing or conducting the dispute resolution process in a fairly hostile environment for some time. And of course, the community had very limited resources. The economic impacts were very severe. So by the time we got involved, they had very little resources to participate in the process. Next slide. The photograph I have there is William Bakashisa. He was a bit of a hero of the story. He was the leader of the affected community, and he really pulled things together and held things together throughout the process. A remarkable man. Next slide. So how did this play out? Firstly, there was an agreement to go to dispute resolution, not a compliance exercise. The CAO did a lot of work to help the community sort out issues of representation and mandates and so on, the setting of the table for the dispute resolution process. A lot of effort had to go into that. As I say, dispersed community, lack of resources and so on all played into that. We spent a lot of time with capacity building, just helping both parties get to a point where they could face each other across the table more or less as equals. So there was a lot of skills development, access to information. We tried to level out the access to information. We did some research, various other efforts. And then we entered a facilitated negotiation. Next slide. Some of the outcomes: a framework agreement was eventually signed, and that led to a final agreement where the terms of the final agreement was really, although underlying all of this, there was this very powerful need for resettlement that remained, but because, and compensation, because we couldn't really go that route. The way that the final agreement came about was the parties came up with a joint development plan, joint development program, financed by the company largely, where the community set up a community cooperative that received support from the company, and the cooperative went and purchased land that they could hold title to. So it eventually was freehold title that the cooperative held on behalf of the community members, and the cooperative then provided leases to its members. It parceled the land and leased portions of land to its members. And the other part of that agreement was that the community would actively assist the company. So this is a forestry company. Forests are incredibly vulnerable. Fire is a major issue for forests, and there was constantly the threat of community retaliation against the company. And part of what this agreement entailed was that the community would actively work with the company to secure the forests and to recognize the right of the company to operate as a commercial forestry business on these forests. I'm running through this fairly quickly. We also did a lot of work to establish a network of other NGOs that could support the community in the resettlement efforts. And one that comes to mind immediately was a water and sanitation NGO that has done a lot of work with the community in the resettlement process itself. And then the company built infrastructure, schools and a clinic and a community center and so on. The company helped build. Okay, next slide. As I've mentioned, the implementation of this agreement was a 4-year sort of phased agreement. And the CAO monitored it throughout that process. The upshot of all of this is that at least these families have security of tenure. The land is, as I said, owned by the cooperative. They can't lose that land, and the cooperative doesn't have the right to sell the land. So the cooperative is tasked with holding this land on behalf of the community, and community members get lease agreements on the land, long-term leases, where they can slowly rebuild livelihoods and conduct economic activities. Next slide. Oh, that's just the close. So yeah, I mean, it was a resettlement through a negotiated process. We never went to a compliance exercise. So, you know, whether all the terms of the performance standard were met, I think that's, you know, that's in the outcomes of this process. Hopefully we can illustrate that those terms were ultimately or eventually met. Whether the performance standard was breached, as I say, it wasn't the task of the role of a dispute resolution process to determine whether there was a breach. But the company and the community did decide to go dispute resolution. So I guess that tells us something about how we got there. Thanks. I'm very happy to take questions or comments. I've gone through this fairly quickly, and as I say, it is a bit of a complicated picture.
Thank you, Ben. We will take questions and answers at the end of the 3 presentations altogether. So there is one question on the chat box for you, but you can respond to it later.
Okay.
So now we move on to the presentation of Professor Antrat Hartman and Dr. Lalana Silva on a compliance review case. Lalana, are you sharing your? You are sharing yours.
I'm going to share my screen. For some reason, my screen is frozen now. I don't seem to be able to move my screen at all. Safa, do you have the shots?
I'm sorry, but I can't find your slides. If you send them to me by email right now, I'll share it.
Let's hold on, because my screen is completely frozen right now.
I have your slides, Lana. I can share your slides if you want.
Do you have them?
Yeah.
They may not be I did send it to Paco. Is that the latest version you have?
Yeah.
Okay. Can you share it?
Mm-hmm. 1 second. You see the slides, Lana?
Yes, we see them.
It's Lana there, Paco.
Lalana, where is Lalana?
Sorry about that. Can you hear me?
Yes, we can hear you.
All right. So thank you, everybody. Again, sorry for this little technical glitch. Anna and I were members of the compliance review panel of the Asian Development Bank. I joined in 2012, and she joined a year and a half afterwards. And one of the first cases that we dealt with was this case from Cambodia. and we will present that to you today. It was a compliance review case, so the compliance review panel only handles compliance reviews, and we had to do an investigation. It was a case that had gone for mediation to what is called the Special Project Facilitator's Office in the ADB. The two functions are separated out, are handled by two separate officers in the Asian Development Bank. And that's how the case came to the compliance review panel. Next slide. So we start here. So I just have a few pictures to introduce the kind of facts, and I'm going to run through them fairly quickly. This is an iconic picture which we'll find on the internet. It is the Pol Pot regime, which you might have seen through the famous film Killing Fields. This was a very brutal regime that took over Cambodia, and here they are seen in actually riding this railway, which was the subject of this project. And they did use this railway for the transportation of arms up and down the country. And also China gave them assistance to maintain the railway. But after the regime fell, the railway went into disuse. Next slide. And once it went into disuse, the Asian Development Bank decided to fund a rehabilitation project at the request of the government. And the rehabilitation project was originally intended to rebuild the railway and start operations again from the southern city of Sihanoukville, which is a port town, all the way through Phnom Penh, which is the capital of Cambodia, up to Poipet in the north, which is literally on the border of Thailand. So this was next slide, a 600 odd kilometer long railway system. And as you can see here, the system had fallen into disrepair. It was the stations, that is a station there that you can see was abandoned. The Batamang station had been abandoned. And next slide. Here you see another picture of a station as well. Next slide, please. Yeah, that's another picture of the station. Carry on. And here what then happened was people began to come along the railway line, which had been abandoned. The railway wasn't running anymore after the regime fell, and started settling down along the either side of the railway line. They also used the railway line, and you can see pictures of that in a minute, but these houses were literally slap bang on the railway line in some places, a little bit set aside from the railway line in other places. Here you see, for example, the housing was right next to it. Many of them were slum dwellers, mostly close to the city centers, which the railway ran through. And these were mostly very poor, marginalized, vulnerable people who were day wage earners, would go into the city, earn their day's wages, come back and put some food on the table, literally. On others were running, little garages, repair shops, little shops out of these dwellings that had come up on either side of the railway line. Next slide. Now, one of the interesting things that happened as a result of the abandonment of the railway was people still started using the railway line for transportation. And this is what has come to be called the Cambodian bamboo railway. And it was a very simple device for 4 iron wheels with a bamboo slat on top and a motor, which would then transport people and goods up and down the railway line. And this is called the bamboo railway. And here you see the bamboo railway in operation. So there was a group of people who actually made a living out of the abandoned railway line. Next slide. Now, so the project itself was to rehabilitate the 642 kilometer long railway from the southern town of Sihanoukville to Poipet in the north. But unfortunately, only about a third of it was ultimately built through this project from the southern town of Sihanoukville to Phnom Penh, the capital city. The rest of it couldn't be built because the project ran out of money. The ADB loan was for $42 million US, and there was also a contribution that came from the Australian government. The first operator with whom the government was negotiating was also an Australian railway company that was to run the railway line. The project involved the involuntary resettlement of 2,629 households. So that's a very large number of people up and down the railway line. And this number converted to about 4,000 plus actual individuals who had to be moved. There was a resettlement plan which was prepared, which is one of the things that is required as part of this performance standard. And it was also required under the Asian Development Bank's own safeguard system. And however, this had been prepared, but at some point in time, the project delayed to be implemented. And unfortunately, the plan was not revised and changed as it should have been done at the point at which people were being resettled. Now, there were 5 resettlement sites along the railway line. The original sites chosen were actually very close to where the people had been along the railway line. But because of the delay in the project, the government could no longer afford those sites because they were very close to the cities. And so they abandoned those sites and instead selected resettlement sites which were quite far away from where the people were settled. Some of them were 7 miles away, some of them were 12 miles away. And this eventually became quite a big problem for moving the people. Now, the project was categorized as category A, which is for environmental and social purposes, which is like significant irretrievable impacts. Those projects are categorized as A. Next slide. The project was, as I said, delayed. It was actually delayed for 2 years, mostly because of negotiations between the government and this Australian railway company. And the final designs were done in 2008. Now, the final designs resulted in an actual increase in the number of households by about 30%. So the number of people displaced actually went up as a result of those designs. Because originally only the people right next to the railway were to be moved, but then they realized that they also needed a reservation for safety purposes on either side of the railway. So this involved displacing and moving a lot more people than they had originally envisaged. Compensation payments were said to have been completed by 2013. And only about 50% of the affected households actually moved to the resettlement sites. Not everybody moved because many of them said, we don't want to move because this is where we have our earnings, make our earnings, and it doesn't make sense for us to move. So only about half the number actually eventually moved to these resettlement sites. Now, it's also important to mention that, as Tiffany said, the government had actually arranged to give people title to these new properties that they were being taken to be resettled. Where they were essentially squatting, they were essentially trespassing and had no title or rights to the land. Next slide. Now, it's at this point that the complaint was actually referred. There were 22 people who complained originally to the Special Project Facilitator's Office. And after the attempts of mediation, it was then referred to the Compliance Review Panel in 2012. Confidentiality had been requested by the people who complained, then it was granted. And the complaint was then declared eligible. That is a threshold that has to be crossed. And then the board approved, the ADB's board approved the compliance review in terms of reference that had been crafted by the compliance review panel. And so that's when the investigation actually began. Next slide. Now, the main allegations in this complaint was, of course, that there had not been proper information given to the people, and that there had not been adequate consultation. As you heard from Tiffany, that is an important element of this particular performance standards. They also complained that there was the grievance mechanism that had been established or said to have been established didn't properly function at all. They said they had not received adequate compensation, that their properties had not been properly valued, that the income restoration program was hopelessly flawed, that their income was not being restored, and the moving allowances, which goes as part of the compensation, had also not been properly calculated. So essentially, significant undercompensation. The resettlement sites themselves, which they were moved to, did not have electricity. In many of them, there was only very poor water supply or no water supply at all for some time. And many of them had problems with the access roads, which during the monsoons would go underwater. I already spoke about the income restoration program. And as Tiffany said, when you move very poor people from one place where they're settled to another place, and you do not provide them with the right compensation, you do not give them income restoration, what happens is they fall into more debt. they become poorer, they become worse off, and they start borrowing. And you have all these usury lenders around them offering them money at very high interest rates, and they then become prey. And there was a high degree of indebtedness amongst the people. This was another aspect of the complaint. And on top of all this, there was a complaint about human rights violations. There's a number of human rights that had been enumerated. And the case was actually brought on behalf of these 22 people. There was support from Inclusive Development Cambodia, which is a very well-known civil society organization, an NGO. And it was led by a very well-known lawyer, David Tredd, who is well-versed in bringing these kinds of complaints to redress mechanisms. Next slide. We did an investigation. As usual, there is at the beginning a document review. We interviewed ADB's staff, both at the headquarters and in the Cambodia office. Both Anna and I were involved in those interviews. We did interviews with the Cambodian officials. Many of these Cambodian officials were very young graduates, because after the Pol Pot regime, which literally killed off the intelligentsia of Cambodia, the bureaucracy of Cambodia at that time was pretty young, actually, and pretty, very young officials who man these various functioning agencies. We also interviewed the consultants and NGOs concerned. We had meetings with the complainants and other affected people. And we paid visits to these resettlement sites, sat down with the people and actually interviewed a large number of them in several meetings that we had in 4 of those 5 sites. Next one, next slide. So then this is just a slide of where, can we go back to the slide, please? To the picture. So this is actually a picture of the resettlement sites. As you can see, this is not very much different to the way the other houses were where they were resettled, but you can see there's a lot of things here that are not yet really completed. So with that, I'm going to hand over to Anna to continue.
Okay, can you hear me?
Yes, we can hear you. Go ahead, Anna.
Wonderful. So our findings were that indeed, the resettlement plan, the original plan was flawed, but more importantly, that because of the delays and the relocation to sites much further away from where the people originally lived, the 2006 resettlement plan was not appropriate anymore. It needed to be substantially revised, and our finding was that the ADB staff and management did not insist on the revision of the plan because where people were differently impacted because they needed to relocate much further away. We also indeed found inadequate information consultation. We found that the compensation was not adequate because it was not inflation indexed and there was significant inflation, so there was undercompensation. And indeed there was high indebtedness of the people we could monitor, namely those which moved to the sites. And that was for 2 reasons. One, as Lalanat already stated, the undercompensation, but equally important that these people arrived very poor on sites. We are told now you will have titles, and there were the money lenders which induced them to borrow high amounts of money for better buildings, which essentially these people could not afford. And there was no assistance provided by the government or other institutions which could have been engaged in the design or in the project, and people were left by themselves to fend off these lenders and were induced to take out high loans. We also found that indeed the infrastructure of the sites was not adequate. Next slide. So we indeed concluded that there was harm to the complainant and to other affected people. Since it was a compliance review, we didn't only focus on the complainants, but indeed to all affected households. And that the harm was caused by ADB failures to assure that the involuntary resettlement policy was indeed adhered to. Next slide. We recommended we made recommendations. One, a compensation deficit scheme. And there we applied rough justice. And this is actually was the heart of the recommendation. And I refer back to Lalanat on that.
So just to expand on this idea, we were dealing with 4,000 people, 2,000 plus, 2,600, 700 plus families. The question was, how do you compensate or provide the deficit compensation to such a large number of people as quickly as possible? Because you're dealing with very poor people who have been further impoverished by result of this resettlement. How do you get funds to them very quickly in a way that is still methodical? So what we decided, but I actually, having discussed this with Anna, drew on my previous experience with the United Nations Compensation Commission, which dealt with war damage, actually, from the first Gulf War. We had used methods of what we call mass claims processing techniques. How do you process large numbers of claims? And sometimes insurance companies do this as well. And so what we came up was a suggestion that maybe mass claims processing techniques should be used. There had been an earlier project of a roadway in which very similar situation, very similar resettlement issues had arisen. And they had done what is called a resettlement audit. And that had taken several years to conclude. And we told ourselves that is not going to work here. So we said, do some mass claims processing. Everyone may not get exactly what they should, but they might get a little bit less or a little bit more, but that's okay. What we want you to do is rough justice and do it quickly. And so that's what we actually suggested here in the compensation deficit scheme. Now, the board accepted the principle that they needed to be compensated adequately, but they didn't want to go with the mass claim system. Instead, they actually asked the government to redo some of the compensation measurements and so on, which is what they did. But that took another 2 years. So let me hand this over to Anna to continue.
Well, then indeed, we concluded that you have to, if you place people on resettlement sites, and I say in some cases in the middle of nowhere, you need to provide adequate infrastructure, water, roads, etc. And then next point was that if these people ended up in high indebtedness because of undercompensation and because of unprotection when coming to the site, the debts need to be worked out. That was a very contentious recommendation. And finally, indeed, if one moves people many miles away from where they originally lived and where they typically earn their income to some sites far away from their income source, income restoration is a key focus. Next slide. Now, this compliance review investigation had one of the more memorable board meetings I ever attended to this. It was very contentious, these findings. The developed countries, especially led by the United States, felt completely endorsed the recommendations. In fact, the US even felt we should go further. The developing countries felt we were far too intervening, or we were too prescriptive. And in addition, there were objections. Why some constituencies objected why, in fact, Cambodia should pay for it, that if we find that it was in fact ADB staff and management non-compliance, which is the task of a compliance review. It was quite a contested discussion. In the end, the recommendations were approved. Main concerns about where we needed to make adjustment is on the debt workout scheme and the income restoration. Particularly, the board shareholders felt that the debt workout scheme might not be appropriate, that it leads to free riding and very contested issue on debt workout scheme. Eventually, we had it in there, supported by the Australians, which felt very committed to it. Yeah, next slide, please. Now, overall, this program was quite successfully implemented. We monitored, that was very important. The ADB monitored for 5 years with annual site visits. That was very important. And the monitoring was carried on for a long period. 5 years is, even by ADB standards, a long period, but it was done very diligently. Important was that there was a board committee which was very engaged. The ADB has a board committee, particularly working with compliance CRP. That in this particular case was very helpful because the board showed particular interest. We were, I would say, the program was mostly successful on compensation, was done on a timely basis, reaching not all, but most people. The only concern we had that, in fact, because of the further delay, there was again some under compensation because of inflation. And at that point, there was not a commitment to again make inflation adjustments. Infrastructure was upgraded in most resettlement sites. There's still some pending issues based on the last monitoring report. Now, the key concern, and that's important as a lessons learned on resettlement. In this case, originally only 50% of the people moved to the resettlement site, where the income restoration was provided, where the debt workout scheme was provided. However, of the people who actually moved, when I left at the 3rd years of monitoring, there were only 25% of those who left still on site. The others had to leave because the moneylenders closed off their building and said, we want our loan back, or the income restoration didn't work or came too late and they needed to go back to the cities to earn money, so they couldn't afford staying on the site. So that was very disheartening, that all our efforts on the income restoration, on the debt workout was really only focused in the end on 1/8 of the population group, of the resettlement group, because only 50% moved and only of those 25% stayed. So the next slide. As a result, we would say very successful in spite of some undercompensation on the mass compensation, done by the authorities, done reasonably fast, reaching most people, not all. The question is much less successful, I would say, on the other points, primarily because by the time we came in with the income restoration and the debt workout scheme, so many people had left already, and very likely the more vulnerable. So, I mean, that's our second point. Timing of the remedy really matters. It makes a difference whether you come 2 years later with an income restoration scheme after the people had been resettled, because by that time, many of them will have run out of funds and fallen off to moneylenders. As Malala had said, we pursued this rough justice scheme, which we felt was successful. Overall, we still consider this case a successful remedy case, much more successful certainly than many I have seen or have been worked on. And I asked myself why. And I mean, we try to identify some criteria or factors. There was certainly firm leadership from my esteemed colleague Lalanet, and just, I would say probably also for myself. And we were privileged by having an enabling environment, by a board committee which was interested and supportive. We had a powerful, active NGO, not only in Cambodia, but also in the United States, which was making pressures, which were articulating. That actually was quite an unusual constellation, but I mean, a remedy can be achieved if you have leadership, enabling environment, and a clear program. And lastly, speaking about the clear program, I thought, looking back in my long career in the mechanisms, this was a program where we had a very careful and responsive management action plan, where we outlined what needed to be done in response to the recommendations. And we got the approval from the board after some debates, but in the end it was there. When we had effective monitoring, we had a board committee which wanted to make sure that it actually was monitored. So the management action plan with this enabling environment at least allowed us to achieve some significant results. Thank you.